served upon the petitioner.
We'll do it.
Yes,
I have served, but not.
all right. We have considered the materials. So how long you're in custody?
139.
160. You have considered the such a subject things in custody for yes, what do you want to say about it? Very good, it's a different number. The prisoner is in custody for 137 days. He submits that he has been falsely implicated. He prays for bail and a lawyer for the state opposes the prayer for bail. Victim is a deaf and dumb girl. She contends that petitioner lured her out of the house on the by offering ₹500 and molested her. In light of the abusive incriminating material and nature of crime, incriminating material, nature of crime, and vulnerability of the victim, we are not inclined to grant. Next.
15.
After that, one extended by the honorable court. I am taking the head of that.
Rajara has been granted. Actually, the three accused persons are there. One Papa is there, who is in item number 19 today, madam, in the list. And another, this Rajkumar Rai, and one Papa.
It's not. No, this person is the principal accused. And Raja was granted bail on the ground with another.
Another, that is this person. Papa.
What for?
At the date of the principal question.
There are call details. The allegation was that after the body was
Petitioner is in custody for how long?
305
days. Who accused Raja Rai has been enlarged on bail. Petitioner prays for similar bail. The lawyer for the state opposed the prayer for bail. We have considered the materials and submit that petitioner is a hired killer. We have considered the materials on record. Petitioner stands on the same footing with who accused Raja Rai, who has been enlarged on bail. There is no possibility of trial concluding in near future. Under such circumstances, we are inclined to enlarge the petitioner on bail also. subject to same terms and conditions. Hello.
Sixteen. And for the petition.
Yes.
137 to 140.
Victim recovered.
Yes, Lordship. A man of 40 years old man, my Lordship, out of business transaction, they went on a trip, my Lord, thereafter, just to recover the pending money, they pressurized him.
How
This is
long
the
you
case,
were in
ma'am.
custody?
160 days, 162 days, my Lord, in custody. Some co-accused have been granted bail by this honorable court, my
The
Lord.
principal, the main money due was
This is the
you are the person, you are the principal person.
Yes, I had the business transaction. 164 statement has been recorded.
Translated. Nepali. Translate.
Find some section.
These are cases of apps. What on bail?
My lord, at
Dinesh
page,
Shiva.
page 12, page 10 onward, my lord.
Dinesh Shiva.
Dinesh Shiva, Suraj Shiva, and Rewaj Pradhan.
But Suraj Shiva is not named in the 162. Suraj, none of these persons are named in the
Names.
petitioner is in custody for 162 days. He submits there was monetary transaction between him and the victim out of grudge. He has been falsely implicated. He prays for co-accused are on bail. He prays for bail. Learned lawyer for the state submit petitioner is the principal accused. He does not stand in the same footing with co-accused who are on bail. We have considered the materials on record, including the statement of the victim. In his statement, the victim claimed that he had been abducted by the miscreants by posing as police officers. He was detained and money was extorted out of him, and money was demanded. Full story. Name of the petitioner transpires in the said statement. Co-accused are not named in the said statement. Co-accused who are on bail are not named in the said statement. In view of the nature of the crime and the role played by the petition, we are not inclined to grant bail at this stage. Next. Yes.
This case relates with 103, that is 304. Now, if you are not, can you see that? Page number 9 to 10, there is a written complaint. One accident took place. And one child aged about 4 years succumbed to his injury. When my prayer for clearance bail was turned down by the Honorable Court, I have surrendered to the CGM Jalpaiguri on 9th December 2024.
Yes. Would you?
My lord, as per my lord, the statement of the mother of the victim boy, Lord, he has voluntarily, my lord, the accused person has taken the child, and my lord, they say that it is an accident, but the mother apprehends that it was a plan to murder. My lord, what is the? That is the statement. That is postmortem report. Postmortem report says injury, my lord, homicidal. No definite opinion was given, but it may be homicidal. The report is page 49, sir.
In the FIR, mother doesn't say murder.
But in her statement before the magistrate court, she has. The rib cage, the injury was in the rib cage of the child. What is that? I clearly submit that there were two other child also in the same toto, but their statement has not been recorded. They were the eyewitnesses.
They're 2-year-old child. What is the age of those children? Huh?
But the child who succumbed to injury is 4 years.
The other two is still young.
Yes.
শিশুপুত্র দীপমন্ডল এবং একই বয়সের দুই ছেলে মেয়ে মৌমিতা আর গুগলু। So they will be 4-year child. What statement? But did they suffer injuries?
They also suffered injuries, but not like the.
They also suffered injuries. And the person also suffered injury. Huh? Did the accused suffer injury? He was in the car.
E-rickshaw.
So e-rickshaw, did he suffer injury?
After first aid, I have released from the concerned medical.
That is not there in the
Please
case.
keep the report on this. Petitioner contends that the minor child had died due to a road traffic accident. Subsequently, he has been falsely implicated in implicated alleging murder. He prays for bail. State shall submit report. State produces the case diary. We have gone through the materials in the case diary. In the FIR, it is alleged the deceased child. It is alleged in the vehicle, apart from the deceased child, two other children, namely Momita and Guglu, were present. Petitioner was also present. No material investigating agency shall submit report whether the whether petitioner and the other two children in the vehicle had suffered injuries or not. Further medical opinion with regard medical opinion from PM doctor shall be obtained whether the injuries on the deceased may be caused by road traffic accident or not. Monday. Next.
18. Now, my lord, for the case is concerned, I am what I think of us. Crime accused was one Roshan Ora. He, being a juvenile, he was a large of bail. If your lordship kindly take the page number 9, that is the written complaint, your lordship will find.
Statement of witness.
Yes. So far, my concern, when I got the information, I informed the de facto complaint that his daughter is.
Statement of the one Swapna Ora, right of the
Page.
page 86.
The principal accused already on bail. Being expelled.
But we got 161 of the same.
You are putting a reading us a statement which is exonerated. The witness is saying, "Ami kichu jani na." This is the way you assist a court.
161 is different.
This is the way you assist a court as a prosecutor. You will ensure that you are removed from the panel of prosecutors.
The lordship kindly consider the page 13. 161 statement of the same Swapna Ora.
We have considered the materials on record. Statement of witness shows there was altercation between the victim, between the petitioner and the victim, a minor girl. Thereafter, victim was taken to hospital in a case of poisoning. In view of the aforesaid incriminating materials on record, we are not inclined to grant bail at this stage.
And get great.
Next.
19. After the petition. This matter relates with item number 15, where your lordship was supposed to enlarge one another accused of bail. Item 15. Just finish it.
Yeah, one has to remain in custody.
Three other.
Petitioner is the principal accused. He does not stand on the same footing with co-accused. He had called the co-accused to commit the murder. He does not stand on the same footing with the co-accused who have been enlarged on bail. Accordingly, we are not inclined to grant bail to him. Next.
20.
How about the petition?
Yes, understand your motion. 20.
How about the petition? This is petition of section 498 and 307. I am in custody since 71 days.
Yes, let us see the statement of.
Yes, Mahin is there at page.
21 days continuous.
Said too early. You have considered the factors of the statement of the victim wife shows petitioner had set her on fire. Her statement is corroborated by medical report, hence investigation is continuing.
Yes.
Hence, we are not inclined to grant bail at this stage.
I'm dead for later.
Next.
21.
Item number 21, I take the petition on it.
Yes.
Such allegation under section 138, 61 to a Bhartiya Nagrik Samhita 2023.
What is 238?
Lordship,
238 PNS is corresponding to
tampering of the evidence.
200.
Lordship, her name does not transfer in the FIR. Lordship, the allegation is on 8/10/2024, in between 5:30 to 6:30, the de facto complainant buying one scooty came and stopped near his house, and two unknown persons robbed one person near the bush. And Lordship, he lost the complaint. Lordship, statement from the co-accused, Lordship, her name transferred, Lordship.
How long you have in custody?
Lordship, 3 months and 6 days, Lordship. I have a child, Lordship. Lordship, no one.
You have a love triangle with the deceased?
No, Lordship, no.
Yes.
No, my lord. Lordship, nothing.
He is the one. She was in a conspiracy, my lord. He is the one who assisted them by supplying people to cause disappearance of the dead body, my lord. She was all through present, connected to them with phones, with a mobile phone. At or about the time of the incident, my lord, and this is the CDR. March.
All right, but what is our motive?
Motive is to extract money from an army personnel, my lord. He was drunk. He was asking for some favor of sexual nature.
Is the victim the honey trap?
Yes, my lord. She's a part of the chain.
Lordship.
If the person was lured out on the basis of and proposal of sexual association, was the proposal coming from the victim?
No one.
From the petitioner?
No one.
Then from whom?
From two of the accused persons. They approached. He was asking for some sexual favor against money, my lord. They appeared to be players. They offered him. They took him to the house of another lady, where they demanded money from this man. He refused it. They took his ATM card and continuously pressurized and started beating up him. Thereafter, they strangled him to death. And there was another injury.
And at that time, there was telephonic conversation
between this lady, and she sent some people to dispose of the dead body.
After the
incident.
And before the incident, there was telephonic conversation. Was there telephonic conversation before the death or after? You are not aware, madam.
After.
Petitioner is in custody.
She was well aware that this has happened.
Petitioner is in custody for more than 3 months. She submits. She is not connected with the murder. Offense of disappearance of evidence. Murder. Offense of disappearance of evidence is a bailable one. He prays for bail. And a lawyer for the state opposed the prayer. He submits petitioner is a conspirator to the crime. Her co-conspirators had lured the victim on the promise of giving sexual favor. Thereafter, he was robbed and murdered. petitioner helped in disposal of the dead body. We have considered the materials on record. Accused had hatched a conspiracy to lure the victim on excuse of sexual favors. He was taken to to a lady's residence. There he was robbed, and thereafter therefrom uh, he was abducted, robbed, and murdered. CDRs collected during investigation show the co-accused had telephonic conversation with the petitioner who helped them to dispose of the body. However, the telephonic conversations are not prior, but after the commission of murder. In this backdrop, these materials prima facie give an impression that petitioner was an accessory after the crime and not after the crime. Full stop. Keeping in view these circumstances, extent of complicity of the petitioner in the crime, and the possibility, and that there is no possibility, and that there is no chance of abscondence, we are inclined to enlarge her on bail, subject to conditions. Petitioner, while on bail, shall remain within Bhakti-Nagar police station and report to officer in Bhakti-Nagar once again.
Well, the Ashigoro, investigation is being carried on by Ashigoro.
Bhakti-Nagar, yes.
Ashigoro.
Shigor is under, under.
There is a lot of outposts. Yeah, it's basically.
Yes. What is the FIR?
And, huge sum of money, man. You know what? 17 lakhs 37,000. The man, this has been extorted from this person, man. Take a mark, sir. Take a seat.
Is how are you connecting this petition?
They are named in the FIR.
No, no,
Only one is there.
how are you connecting? Who is investigating this?
Yes.
Which investigating agency is investigating? Cybercrime police station.
Cybercrime, Siliguri cyber. But in that case, I'll call the other.
No, Mr. This is a case where custodial information.
My lord.
Petitioner submit. Who is named Mr. Anuruddha?
Because his name is not appearing in the FIR.
What is the connection of Avinash?
They have not received money.
No, they are the persons who are involved in the fraud. That has to be done. We do not know how far these investigating officers are going.
Bank statements are there.
Huh?
Bank statement of
Yes, what bank statement?
the amount has been in Avinash statement.
Credited
Yes.
both to Avinash
Both,
and
both.
Bhagat. And what is the allegation against Bhagat in the FIR?
Bhagat,
Petitioner confirms that he is no way connected, Bhagat, no way connected with the alleged cyber extortion he has been falsely incriminated in the FIR. He has cooperated with investigation. He pleads for action. A learned lawyer for the state opposed the prayer. We have considered the materials on record. The allegations in the FIR depict a case of cyber extortion. De facto complainant is a government employee. Uh, he received a number of phone calls alleging that his objectionable videos will be circulated if he did not make payments. Petitioner is named as one of the accused. As a result, he was compelled, he was extorted to pay money.
Because called it, my lord.
Petitioner is one of the accused who had made the phone call for facilitating the extortion. Custodial interrogation for progress of investigation is necessary. Accordingly, we do not wish to grant and strictly take. আর আগেরটা বলো নেক্সট অভিনেশ বলো নট নেম দি ফার্স্ট ইনফরমেশন আর অ্যালিগেশনে বলবে যে ইনভেস্টিগেশন রিভিলস দ্যাট the extorted money was routed through the petitioner's account. Custodial interrogation to unravel the ramifications of the crime is necessary. According to we are not inclined to grant and
Obstruction or not, we have not. What has it? What is that? What is complete, I think.
Yes, yes, 40.
But I'll show you.
No, don't have to show me. I know.
Okay. Other matters of the file.
My lord.
Well, at 38, I'm appearing online. Am I audible to your lordships? Am I audible to your lordships? I'm obliged, man. Well, this is one of its kind. The petitioner before your lordship is a hotelier. Now, the husband of the deceased, who is the FIR maker, is a local promoter. A 306 case was filed against the petitioner on the ground that when wife with her daughter allegedly committed suicide, that she owned a piece of land, I pressurized her for transfer. Well, that's a case. There must be a matrimonial discord for which the wife might have committed suicide, my lord. No casual connection, my lord, with the suicide. There's a 306 case against me. Then, my lord, we filed this petition, my lord, when interim order was granted in our favor, my lord. Police never, despite our voluntariness, my lord, police never interrogated me.
There's a suicide note, Mr. Bhattacharya.
My lord, kindly sees the suicide note, my lord. And kindly appreciate, my lord, why would the wife with the daughter would commit suicide with deepest respect? But when it was initially moved, my lord, the postmortem report was placed, my lord. What we could gather, my lord, that the honorable judges, my lord, commented on the postmortem report that this is a case of murder. And earlier, my lord, there was a complaint case filed where petitioner was not made a party. That complaint case, my lord, was mentioned in the FIR.
PM report, PM report, two PM reports are there, on page 40 of, this is Lata Sarkar and 43 is the Asha Sarkar. 40 and 43. We have received the, handwriting expert report, man, page 130. Yeah. 43 and 40. 40 and 43. 2 PM reports are there.
The daughter has been murdered and the mother has committed suicide.
We have received in the meantime, my lord, we have received the handwriting expert report, my lord, page 130. And my lord, brother-in-law of the deceased, 164 statement is recorded, my lord, page 31.
Handwriting report says what? It is handwriting of the
Yes.
mother. But how the daughter suffers head injury?
That is, which is still in progress, your lordship. 164 statement of the brother-in-law of the deceased, mother of the page 31 and 32.
Okay.
correct circumstances in which the girl is my dad is not coming out from any of these things.
Now,
Who was there in the house? Nobody.
nobody. At that time, nobody.
Huh?
At that time, nobody.
When did the father leave the complaint husband?
Actually, my lord, I am presenting on behalf of the defector complaint.
Yes, when did he leave the house?
Actually,
Your daughter
Ah.
has been murdered
Ah.
and you are making a false case of suicide. Sir, we would have in a minute rejected the application of the petitioner. But for the fact that you are not coming up with the truth, this is not the truth.
the actual fact is that that my wife first murdered my daughter. Subsequently, thereafter,
Why did she murder your daughter?
because
Or is it you murdered your daughter and
No.
your wife committed
As per the
suicide?
instruction of my client, there is a door is locked. There is a videography also. The door is completely locked. In the early morning, I left the house for some certain purpose.
What certain purpose?
For some work.
What is that work? That is exactly where you require to come out in the clear. What is the work you left for? Because you were the person who is the other inmate in that house where a murder takes place, and you are covering up the murder by saying it's a suicide.
The postmortem revealed that this is suicidal. Actually,
Which postmortem will be okay?
postmortem
Let's see.
43, madam. 43.
Which
Yes, sir.
either this postmortem should not be believed, or this cannot be a case of suicide. Just tell us in which way you explain this death as suicide. Someone has a submural hemorrhage on the occipital region of the brain and dies. In what manner it is suicide?
The disease that is Lata Sharkar on the postmortem revealed that it is suicidal.
We have no doubt that Lota committed suicide. But we are concerned about Lota's daughter. How did Lota's daughter suffer a head injury and die? And you were the person who was in that house.
Actually, I do not know why.
Correct. Why you do not know? You should be subjected to interrogation. You should be arrested. Isn't it? Until and unless you make it very clear what is your activity.
The suicidal note is very much.
Wonderful suicidal note. How do we know that it was not a product of coercion at your end? We don't know because of the falsehood. Truth is very essential. If you cover up your tracks by making false statement, you put yourself into the pit.
My lord, my own submit 1.8.
Sir, we will direct your arrest until and unless you come clean how the circumstances led to the death of your daughter and the suicide of your wife. We have no doubt your wife committed suicide, but we have every doubt as to the circumstances which were prevailing on that time, which results in the head injury of your daughter and a purported suicide note implicating these petitions. If there is a murder, then there can always be extortion to make a person write a note implicating third parties. How do we know?
The disease.
All right, take down.
My lord, one submission.
Sir, next submission, your client is in jail, and we make this investigation open-ended. Who is the investigating officer?
He is not present today, my lord. He is not present today.
This investigation must be handled with due caution.
Yes.
How this person, how the girl commits murder, dies is most important.
I along with learned APP, my lord, suggested with talk with the IO and you.
All right, let us do like this. We don't pass any order on this.
Yes.
We are transferring this investigation to the superintendent of police, Jalpaiguri, or is commissioner.
Commissioner.
Siliguri commissioner. The commissioner of Siliguri Commissionerate will investigate the crime, particularly the two circumstances. A, the head injury resulting in death, whether that death is homicidal or not. Two, the suicide note. Right?
Yes.
And we are keeping it after 1 week.
Most obliged.
Context that the de facto complainant husband is responsible. Context, there was a matrimonial, there was a domestic quarrel between the de facto complainant husband and the deceased wife and his wife and daughter. His daughter was murdered and wife committed suicide. He has shifted the blame upon the petitioner and others. In order to protect himself, he has lodged a false FIR alleging petitioner and others have abetted the suicide of his wife and daughter. Suicidal death of the daughter is in view of the nature of the injuries noted in the PM report. Suicidal death of the daughter is improbable. He is ready and willing to cooperate with the investigation. He prays for answer to the bill. Learned lawyer for the state content. Victim lady left behind a suicide note implicating the petitioner and others. Suicide note is in her handwriting. However, he is unable to give explanation how the daughter's death, how her daughter's death is described as suicidal, though it is noted in the postmortem report that injury is suicide, that she died due to head injury. Learned lawyer for de facto complainant submit he was not present in the house and the room was locked from inside. He was not present in the house and the room was locked from inside. Good stuff. We have considered the materials on record. The case throws up various imponderables. In the first information report, de facto complainant husband alleged petitioner and others are land brokers. They are land mafias. They subjected his wife and daughter to harassment and cruelty. Harassment. Out of depression, they committed suicide. But the postmortem report of the daughter, now it is true, the wife's suicide note indicates the petitioners. But the daughter's postmortem report shows she died due to head injury, which is head injury, which prima facie does not appear to be suicidal. Good stuff. De facto complainant is also de facto complainant was the other inmate in the house when the incident occurred. He contends that he had left the house in the morning, but is unable to disclose his whereabouts. Good stuff. His whereabouts. investigating agency has also investigating agency is also unable to answer the suspicious circumstances in which the de facto complainant's daughter suffered head injury, died, and the suicide note and the purported suicide note would stop. In such view of these circumstances, persuade us to transfer the investigation to a specialized agency. We direct the investigation, we direct Commissioner of Police, Siliguri Commissioner, to take over the investigation of the case and conduct the investigation and conduct the investigation under his direct supervision through an officer not lower than the rank of Assistant Commissioner of Police. The investigation shall inter alia direct itself to the following issues: (a) circumstances in which de facto complainant's whether the de facto complainant's daughter's death is suicidal. If not, circumstances in which she suffered head injury and died. 2. Attending to whereabouts of the de facto complainant at the time. 2. De facto complainant was the other inmate in the house. His whereabouts around the time when the incident occurred. 3. Authenticity, attending circumstances in which the suicide note came to be, suicide note had been written. Suicide note had been now. Whether the suicide, attending circumstances in which the suicide note came into being. Report with regard to progress of investigation shall be filed on the adjourned date. Investigation shall the investigating agency shall conduct the investigation in a free and impartial manner, including the role of the de facto complainant if necessary. Report with regard to the investigation shall be submitted on the adjourned date. Matter will appear on Tuesday. That is 28th.
My lord, interim order may continue, my lord.
We don't know.
My lord, interim order, but so that I can also participate in the investigation, my lord.
If you are taken into custody, nothing will happen. Next.
My lord, if it may continue till Wednesday, my lord, I'll come back on Wednesday, my lord. Your also will pass necessary order on Wednesday.
Neither are we stop.
Because so
We are restraining arrest of de facto complainant, nor are we restraining arrest so far as you are concerned. The main area.
no, but I had an interim order, my lord, which is why I am requesting, my lord. I had an interim order, but till 17th I had it, my lord, up to Friday.
Next,
Will you
matter.
communicate the order or registry will communicate the
You
order?
will communicate the order. Investigating officer shall be present in court on the adjourned date. You understand your inability in the investigation. You have scored 0 in explaining a death which apparently is not suicidal. Even the 164 statements. Paperwork will not do. This is something which is much deeper than paperwork. 2 women have died under most suspicious circumstances. And you go write a few statements and your job is done. Sorry, no, we want to go to the root and the truth of it.
My lord, may I request for extension till Wednesday, my lord?
Next.
Obliged, my lord. Obliged.
Lordship, item number 39, I'm led by senior advocate Mr. Ramlesh Rai. He's appearing before the principal bench. Only claim for not deceived, Lordship.
No, sir.
Lordship, actually, the AOR just got married last night. So
What?
the advocate on record got married last night. So he's the marriage ceremony, Lordship. Only praying on that.
Monday.
Grateful. Grateful.
On prayer of petitioner adjourned Monday. Next.
My lord, in for the petitioner in this case. My lord, nothing, this is a matter under the NDPS Act and nothing has been recovered from
Yeah,
the.
investigation going on?
No, my lord, the charge has already expired. And-
Statement, this petitioner named Lordship, 29 total of costs.
Yeah. We have considered the materials on record. The petitioner content, no narcotics was recovered from his possession. We have considered the materials on record, 29 bottles of fentanyl syrup was recovered from co-accused. It is contained statement of co-accused, from co-accused, complicity of petitioner transpired from statement of co-accused, the police. It is contained statement of co-accused is inadmissible in law. However, petitioner was not available during investigation and had absconded.
My lord.
Under such circumstances, further investigation took place. Yes,
Kindly come to the order, page number 11, my lord. Kindly come to page number 11.
yes.
My lord, the bail was granted on 2 grounds, my lord. There has been a non-compliance of section 14 of the NDPS rules, as there has been a delay in the submission of furnishing the FSL report, and as there is a contravention.
Further,
And second point is, my lord, paragraph number 2 of the said order.
you will also be granted bail, madam. But we are not going to give you anticipatory bail when co-accused absconds and comes before us for after investigation.
Co-accused never absconded.
Oh, all right, why didn't you go and meet the investigator?
My lord, there is a non-compliance of the provision of the NDPS Act, my lord.
Brilliant. We don't, that order, you want us, it's a coordinate bench order.
Yes, sir.
At least we wouldn't have passed that order. That is no non-compliance.
Even there is a discrepancy in the season list, my lord.
Very good. Those are things for trial, no ground for bail. Good luck to your co-accused who has got bail. You will also get bail. We are not going to give you excuse. Further investigation. Further investigation, including custodial interrogation, shall unravel the complicity of the petitioner in the crime. Hence, in view of the nature of crime attracting restriction to the NDPS Act, and as petitioner was not available for interrogation during investigation, we are not inclined to grant a Next.
41.
41.
Yes. 69, victim intimated. Intimate victim. Add victim as a party respondent. Officer in charge, Calcutta shall intimate victim 24. Next. Amend the cause title. Add victim as a party. Here it is sexual intercourse on false promise of marriage. So please inform victim. Victim will be a party here. Next.
307 Lordship, 3 accused person, 2 accused person arrested, and they are granted bail.
Sir, consider the materials on record, including injury report.
Lacerated injury more than 100 stitches.
100 stitches.
100 stitches in the left arm and right arm, and the fractures of acromion, that is the shoulder blade.
You have considered the materials on record. Injury report shows reverse life-threatening injury in view of the statement of victim and witnesses implicate the petitioner in the assault. Accordingly, we are not inclined to grant answer. Next, 43.
Particular, I need one day accommodation, my lord.
The petitioner needs more days accommodation. Where is the petitioner? Anil Kumar Mormo.
I kept to know that the Mr. Father is ACLP,
Which Mishra?
filing lawyers. Subhashish Mishra.
Moshish Mishra is father-in.
Yes.
Where to, when should we give? Tomorrow?
Tomorrow.
Tomorrow? When will he be available? Tell us. Ask Subhashish, whenever he is available, we'll take it as form.
Yes.
Day after tomorrow?
Day after.
Day after. The inform. Next.
Services. But after 5 days of the alleged incident, what this FIR has been involved, kindly see our involvement.
70. 64 or 70?
But 71.
70.
But kindly see our involvement. Kindly see
Whatever involvement. We have
kindly see the one signature, one part.
that there is delayed lodging first information report on this for.
There is no allegation of rape, kindly see.
There is a learned lawyer for state opposes the prayer. We have considered the materials on record, including statement of the victim under 183 BNSS.
But we are Abdul Masood, Robiul Alam and Rafiqul Islam. Thanks.
Our statement implicates the petitioner. Implicates the petitioner in the crime, keeping in mind the nature of the crime and emphasizing implication of the petitioner in the offense. We are not inclined to grant answer.
Wait.
Next.
45. But after 1 year of the alleged incident, my lord, the conflict is was lost.
How many years after marriage?
But 2.5 years.
After 1 year, they lost the FIR.
Yes, 156 plus 3. Incident was not.
Petitioner contends the FIR was lodged 1 year after the incident. They are the in-laws. Petitioner is the husband of the victim wife who committed suicide. He prays for anticipatory bill and a lawyer for the state opposed the prayer. We have considered the materials on record. Though the victim wife committed suicide within 2 years, within 2.5 years of marriage, FIR came to be registered 1 year after the incident. No plausible, no convincing explanation for the delay is forthcoming. Possibility of false implication cannot be ruled out. Under such circumstances, we are inclined to grant answer.
Date of incident was 23rd of March 20 after 1 year.
Next, when did the 156.3 application?
On
2nd of March 2024.
Not that it was lying in the police.
No.
Next.
46.
My lord, this is a case in whereby the sections have been implicated of undertaking of KNSS. Subsequently, my lord, we come to the list of data at the first page, my lord.
Yes, statements. What was the age of the victim?
My lord, 28 years.
Male.
28 years, male.
Male. All right, we have considered the materials.
Not one intelligence. Actually, this person committed suicide at his girlfriend's house. Where what the allegation is that the allegation is the accused actually abetted to consume the poison.
Petitioner, we have considered materials on record. It is contended victim had committed suicide at the petitioner's residence. Statement of witnesses show there was a romantic relationship between the two. Victim had not left behind any suicide note, keeping in mind the aforesaid facts. The possibility of false implication of the petitioner out of suspicion cannot be ruled out according to the inclined. Custodial intervention not necessary according to the inclined.
I know, next. 47.
Who committed suicide?
Daughter of the
Age.
Yes, where the victim is blind, my lord. 164 statement of the person who has my lord recorded video camera there, my lord.
And one thing, the victim confident that there is no time difference. He died on after 3-4 days. And one petition, the petitioner kindly requests
Page 81. This person has recorded the video, my lord, while dying.
no name in the FIR.
We are asking you now. Why can't you hand over documents? Yes, what are you showing? The victim is pregnant.
No name in the FIR, no 61. Kindly see, no name in the 61. Kindly see. And Swamikus first granted bail by the court. Magistrate, petitioner is the deciding father. When incident took place is body of petitioner recently Manavan.
Victim was pregnant.
She was blind, my lord, I don't know.
PM report.
No, my lord.
PM report.
PM report is at PM report, page 120.
There is no pregnancy.
No.
And the petitioner is the
He committed by conscious poison.
Poison, my lord. Page 60.
We have considered the materials of record. Petitioner and others had harassed the victim lady. As a result, she consumed poison. Keeping statements of witnesses indicate the petitioner to be the crime. Accordingly, we are not inclined to grant an assumption. Next.
48.
take the I have pencils.
We have to promise tomorrow. What promise with 380 trespass and rape.
Can you see that? Can you see that?
Let us see.
This is the 160.
Both are married.
Both are married.
There
Where is the promise to make?
There is dispute between they are working together. Can you see page paragraph 8?
You notice the victim. Yes. After in charge, have you made the victim party?
Yes.
I did notice. No, she was working on it.
Next date, madam.
24th. Next.
49.
Next.
But after, but circumstances is not affected. Not statute days of the alleged incident. The FIR has been lodged.
24th. Officer in charge. Matter will appear on 20. Right? Sharp. So 24th is all right.
Yes, sir.
Next.
Actually, in item number 50, I beg to appear on behalf of the petitioner. We have served notice upon the victim, Lordship. The case is under section 137 to 140 subsection 3 and section 3 subsection 5 of the BNS Act. I am the elder brother of the principal accused.
Materials on record, the petitioner is the elder brother of the victim girl. Victim has already been recovered.
Elder brother.
Hiren Borma. 164. C 164.
No, Milord, no, that is incorrect because in the 164 statement, she denies, Milord, that he is, she says that I do not know. Two unknown persons, they followed me and then they abducted me.
All right. Petitioner submits that he is not the principal accused. Victim has been recovered. In her statement, she has not implicated the petitioner. Keeping in mind the extent of the petitioner's complicity, we are inclined to grant that.
Grateful, Lordship.
Next.
In this matter, I take the petitioner. Petitioner is the owner of commercial vehicle with all India permit. So his vehicle will not contravene under NDPS Act was recovered. But in the first charge sheet, my name was not here. In the supplementary charge sheet, my name transferred. Nothing was recovered from me. No statements of any co-accused gets me.
Petitioner is the registered owner of the vehicle.
Lordship, he did not cooperate, that's why he supplemented charge as well. His name is
Where? To whom did you let out the vehicle?
Lord, a driver of mine. Lord.
What is the driver's statement?
As far as my knowledge goes, the driver's statement does not indicate me. From the first day I got the knowledge of this case, I had to put the learned jurisdictional court with a petition for 452 for recovery of
Without getting bail, you can application for 452.
As he was ill instructed at that time, as far as I can see.
Petitioner is owner of the motor vehicle. Motor vehicle, he was not.
Lordship, 161 is not there.
Bring the 161. How can the statement of the driver is not there? Driver was arrested.
Yes, Lordship.
Then what did he say?
Actually, they have handed over the CD, but from the CD, and even the, I just want the accommodation.
Not to ask the Ayub.
Yes, Lordship.
Next.
52. Now we get up. Application number section subsection 5 of the BNS petitioner is the married sister-in-law. She is staying in.
The married sister-in-law of the victim lady. She submits, she has been falsely indicated, she pays for answer. Yes, who is for 62?
And the petitioner is saying.
Yes, what is there?
What is the blunt trauma?
Learned lawyer for the state opposing the prayer, we have considered the materials of record. Petitioner contends she is the married sister-in-law of the victim lady and did not ordinarily reside at the matrimonial home. Possibility of false implication due to matrimonial dispute cannot be ruled out. Accordingly, we are inclined to grant that. Next.
53.
But 53 and 55, as of the same case.
Yes. We have considered the materials on record including
Here with six, no? Committed suicide.
Here with six.
Committed suicide. Husband committed suicide.
And who is Joy Gopal Rai? Wife's brother?
No. Member of the club and all other.
Oh, you are having affair. We are rejecting you.
No, madam. Some were granted anticipated.
They didn't have affair with this man's wife. All are having affair.
No, madam. Affair with one Onima Mondol, madam.
Affair with one Onima Mondol.
Husband.
Wife is having affair with Onima
No,
Mondol.
madam. Kindly, 1 minute, madam.
Yes, what is his
Not a husband has the illicit relation with Onima.
Onima Mondol.
This is.
Then
Problem cropped up and these persons are from the club threatened this petition deceased and
any suicide note?
no, the suicide note is not clear, my lord. 164 statement of
Let us see the first.
son of the deceased, my lord.
Let us. We have considered the materials on record. Statement of the son. Huh?
Equal to 70 by the Honorable High Court, madam. Case available, madam.
Without looking into the suicide, there is an electronic suicide there.
Yes.
3 questions and standing. Rajesh, Prabodh, and Rakesh, madam. 3 questions. There is a counter affair also, madam. By and
Petitioner contends that the victim had an illicit relation with one Onima Mondo. As a result, he committed suicide and falsely implicated the petitioners. Now, petitioner and others have contested when the victim committed suicide and falsely implicated them. They pray for and co-accused have been granted answer. They pray for he prays for similar relief. Learned lawyer for the state submit. Victim had made some victim had recorded a dying had recorded a dying statement implicating the petitioners. We have considered the materials on record, including statement of the son of the victim. He stated that his father had recorded a dying statement alleging petitioner and others had blackmailed. Materials has also surfaced that the victim had illicit relation with Onima Onima Mundo. Possibility of commission of suicide due to mental stress arising out of the illicit relation cannot be ruled out. Co-accused have been granted anticipatory bail. Custodial interrogation is not necessary. Accordingly, they are inclined to grant similar.
Not 55 is the wife. I can 55 is the wife.
not wife, she is the one member. Oh. 55 number, one member, Onima Mondo lost complaint. Can you see the affair, my lord? On the same day, my lord, counter affair, my lord. She was blackmailed by the. This is my comment.
Petitioner contends that she had an illicit relationship with the deceased. She had lodged the deceased blackmailed her. She lodged FIR. As a result, thereafter, deceased committed suicide. Good stuff. She prays for answer. You should have brought up this in the earlier case also. Learned lawyer for the state refers to the statement of the deceased son that the deceased had recorded a dying statement. we have considered the materials on record. Deceased had illicit relation with the petitioner. Petitioner, he blackmailed her. She lodged FIR against the deceased. Subsequently, he made a dying statement. Subsequently, he died. Subsequently, he committed suicide. Petitioner is not named in the dying statement. Accordingly, we are inclined to grant it. Next. See the 56.
54.
54, sir.
You have got the advocate on record for this particular matter, Mr. Gopal Roy.
54.
His father's demise a few days back. He was unable to come to the court today. So
When should we do?
if you could kindly give the matter tomorrow, Your Lordship.
56.
56. Cultivation of
Cultivation of cannabis.
As per all the
Statements of
witnesses.
witnesses show petitioner was indulging in cultivation of cannabis plants. Official police officers seized cannabis plant from the petitioner's father's land. In view of the aforesaid incriminating materials, we are not inclined to grant a surrender. We will give you the.
So should the allegations are under section 406, 420 and 34 of Indian Penal Code. As per the allegation, Lordship, complainant has taken loan from several banks, and this petitioner helped him to secure loans. And thereafter, this petitioner misappropriates the loan by fraudulently withdrawing the amount from her bank. Lordship, the loan was sanctioned in the year of 2022 and the FIR lodged in 2024, Lordship. And at the time of sanction of loan, one message, generally one message goes in the registered mobile number. So it is
Petitioner contends that
Lordships, in another case also, they are taking the advantage of innocent person that they obtained loan and thereafter took signature and obtained everything, thereafter encashed the money. And same type of offense has been committed by the same.
petitioner contends that de facto complainant had taken loan from a finance company. Thereafter, she failed to repay the loan and has falsely implicated the petition. There is delay in logic procedural. He prays for and substituted. Learned lawyer for the state subject petitioner has indulged in similar crime, has criminal antecedents, and has indulged in similar offences. We have considered the materials on record. Petitioner had procured the credentials of the de facto complainant and obtained loan in our name. Thereafter, he misappropriated the money. Criminal case was registered. On such score, criminal case has been registered. On such score, present case is registered. Petitioner has committed similar offense, has also committed similar offense resulting in another case. In such view of the matter, we are of the opinion petitioner is involved in organized crime activity and And his custodial interrogation for recovery of money is necessary. Hence, we are not inclined to grant it.
Say one thing, Lordship, if he is the worker of one cafe, Lordship, has no knowledge about the.
Tell us who has the knowledge.
Lordship, there are other accused persons also.
Correct. Tell us who has the knowledge in custodial interrogation. We will do it. Next.
58.
I have one state.
Yes.
Allegation under section 434 মানে allegation petitioner at the support of the particular political party and there is a fire of a tenant of a Trinamool Congress party. For this one thing.
Anyone injured?
No one.
We have considered the materials on record, though allegations say, show that petitioners had set fire on a tent. No one was injured, keeping in mind the aforesaid circumstances. We are of the opinion custodial interrogation is not necessary and petitioners will be granted and.
Lordship, objection is kindly noted.
Not done in counsel to the party. Next.
59.
Same accused person, 57, item 57. Another case.
Please. Next.
Yeah, I'm 60-40 minute defect comment. The allegation is that the proceedings corporately easily by 14 documents obtained loan from the finance company Miller on the last date Miller 2nd January before the honorable court. He submitted to deposit 35 lakh rupees within 5 days. But till now Miller no amount has been submitted and he is still absconding. Kindly see the last order 2nd January. One minute, kindly see the supplementary affidavit, my lord. So they claiming that 33 lakh, my lord. I stated my lord, in my supplementary 3 and 4, only 90 lakh is due, not 33 lakh, my lord. I paid part payment is made, my lord. I annexed those documents. I want to. No payment has been made. Yes, my lord.
How much is due according to?
19 lakh.
19 lakh.
Yes,
You deposit 19 lakh.
Kindly given installment, my lord. Not in one.
Next circuit, arrest him in the meeting. Supplementary.
One direction to the state, we have few other documents, you inform on the times.
Arrest him in the meantime, we are keeping it in the next circuit. Let him show his dog.
Wait for the motion.
Supplementary affidavit file, place the matter to the next application.
51.
Miscarriage.
Not to be miscarriage, my lord. According to the report, my lord, it was not miscarriage, my lord, it was not because of the kicking, my lord.
Not because of the.
And lordship, the victim especially specifically named Saddam Hussein and Alia Rehman in 160 statement. And my lord, there are around.
You have considered the materials on. No, we'll reject them. You have considered materials on record. Petitioners are land mafia. They assaulted 2 pregnant women and assaulted and brutally beat up 2 pregnant women in view of the nature. In view of the nature of crime and to emphasize involvement of the petitioners, we are not inclined to grant it. Next. One day. Praying for accommodation for long. 68, 471. Not who's the state? Not next.
53.
My lord, I got the petition case under section 376 and 470. My lord,
Notice
romantic relationship between the party, the victim is the complaint is.
give notice to the victim.
Before notice, my lord, I would like to advise, my lord. In the last provision, my lord, they have contacted that the victim and the husband are
Married.
and they are living together. I got the IOS report, my lord. The IOS report says that the victim and this accused are living together and they are married, my lord. If it is needed, then I will
Report is placed on record. Victim and petitioner and the victim have married each other. In view of the aforesaid development, no worthwhile purpose will be served to commit the petition at the custody accordingly. We are inclined to grant petition. Next. We are inclined to grant petition.
My lord, I am for the petition. It's under section. It was of wildlife protection.
Wildlife protection.
My lord.
Wildlife will be out, you will be in bar.
No, my lord.
Wildlife
My lord,
protection.
kindly see,
Tortoise.
only the suspicion ground.
Suspicion ground.
Suspicion ground.
Tortoise.
Suspicion.
What is seized from him?
Nothing, my lord. Actually, I don't know. My lord, it's what happened. I have. Him, there is no apprehension of arrest. He is one of the suspect of our rhino poaching case, Lordship.
You give a report.
Lordship, from the office.
From the office.
Lordship. On 24th, Lordship.
24. Report with regard to involvement of the petitioner to be filed.
Lordship.
Is he an accused in the complaint?
One of the suspect.
Suspicion.
Summons has been issued against him.
No.
Nothing.
Nothing.
The inquiry over.
No pure submitted.
No pure sound.
Since 2014, Michael. Very old case. That is why they are not giving the records. Otherwise, Forest should have produced everything. They are very serious about it.
And I know one very serious.
Yes.
Your abscondence, you go and pay for regular. Petitioner pays for anticipatory bail in a case filed registered in 2014. Petitioner was not available for interrogation during inquiry.
No, my lord, not notice of no, neither.
All right. Under such circumstances, police will consider it prudent to grant anticipatory bail, which shall be open to the petitioner to appear before the jurisdictional court and pay for regularly in accordance.
All right.
Vijay.
No.
Next.
65.
My lord, petitioner number 2 is the owner of the petition. And the petition number 1 is the son of the petition number 2. My lord, they are Indian citizens, my lord. And my lord, the petitioners were boarded the passengers to the bazaar, program for bazaar, my lord. And my lord, suddenly based on officials.
We have considered the materials on record. Petitioners were trafficking Bangladeshi nationals in their e-rickshaw. In view of the nature of the crime, we are not inclined to grant that.
My lord, there is no.
We know what connection is.
My lord, my name.
And we will give you bail, but no anticipatory bail in foreigners. Feeding Bangladeshi from this side of the border to that side.
The place of occurrence is bazaar, my lord.
And actually, they are coming.
And I came to learn that the passengers was the Bangladeshi nationals. My lord, I am not the Bangladeshi. I'm only the Indian citizen, my lord. And my lord, I am resident same part, my lord.
63.
Yes, one second. 62. 62. No. This one.
65.
65. Where were they arrested? How far away from the border?
Near Gourango Bazaar.
Gourango Bazaar is how far from the border? PO and border. Is it within 10 kilometers?
Yes, sir, within 10 minutes.
Next. No, man. If Gaurango Bajar was reasonably inside Indian territory, yes, but not. And naturally, that otherwise, the BSF wouldn't have caught you. Then BDR would have caught you. Surrender will kill you. Next.
I for the petition, your lordship, the case was initiated under section 108 of the 3.5 BNS. Right. All accused named FIR persons are granted bail except your petitioner. The petitioner by relation with the husband and wife. They are not the relative, but they are not the near relation of the victim. Moreover, your lordship, kindly page number 15, annex P3, the honorable coordinate bench was granted anticipatory bail. The near relation of the present victim, that is the FNM 5 and 6 on 4th December 2024, 5C RN number 960. I understand for your lordship. I am not the near relation, not the relative. I am the neighbor of the victim. Victim was male person.
Petition number 1 is the GP member, and petition number 2 is the wife of the GP member.
All right.
In front of these persons, whatever was took place, and
Petitioner submits there was a matrimonial dispute between one Champa,
Shukla
Mohanty and her husband, that is the deceased. Petitioners are members of the Gram Panchayat. Petition number 1 is
Panchayat member and
GP member, and petitioner 2 wife of the petition number 1.
Petitioner number 1 is a member of the Gram Panchayat, and petitioner number 2 is his wife. She did not play any role in their matrimonial life. They have been falsely implicated. Who accused have been granted for PRS bill. They pray for similar relief. Learned knowledge for the state opposed the prayer. Statements of witnesses show a quarrel had broken out between the deceased and her wife, Shukla Mohanty. Petitioners had abused and as her petitioners and others had abused and assaulted the deceased. Would stop with the conduct of the petitioners to intervene in accordingly, we are inclined to extend similar same relief.
Get for your lordship.
Next.
67, I put the petition. Allegation under section 440, 436, 437, 379, 34 of the Indian Penal Code below. Because actually the allegation below, heart was found by petitioner below, that there is civil dispute, injunction granted in favor of us below. That the lady who has granted and by the court.
We have considered the statements of witnesses. Petitioner had burned a market, resulting in extent. Market or how?
Tin shed. Tin shed on the land. This is the picture.
Petitioner had burned a tin shed of the de facto complainant. There is a civil dispute between the parties. To stop, possibility of false implication cannot be ruled out. Accordingly, we are inclined to grant that. Next.
68. Not place is out of 4 that 3 accused persons are already dead, anticipated is page 97 onwards. Here the purchase the land, forced land, which is procured by the other accused. Page 97 of the FNM Act, all the FNM Act person are directed anticipated for the
Coordinate with person.
Petitioner contends that he is an innocent purchaser for value, who accused have been granted ancillary he pays for similar relief that a lawyer for the state proposes the prayer for bail. We have considered the materials on materials on record. Who accused have been granted anticipatory bail. Petitioner is the purchaser of the immovable property. Accordingly, alleged forged documents are in custody of the police. Under such circumstances, we are inclined to grant a similar view. Next.
59. Allegation is under section 126, section 217, subsection 3.
Yes, injury.
My lord, injury, deeper injury over the left thumb, my lord, but the nature of injury is little simple. My lord.
We have considered the materials on record. Allegation of injury report shows injury is simple. Whether petitioner intended to murder the victim has to be assessed at the appropriate stage of the proceeding. Keeping in mind the opposite facts, we are of the opinion custodial interrogation is not necessary and petitioner may be granted. Next.
My lord, item 17, I am for the petitioners. The allegations are under section 498A, 3 and 4 of the DP Act. Petitioner number 1 is the husband. Petitioner number 2 is the father-in-law. Petitioner number 3 is the mother-in-law.
Is the nature of
498
allegations of cruelty are general
3 and 4. Dowry order notices have been issued. Let them appear.
Custodial interrogation is not necessary. However, petitioner is required to cooperate with the investigation.
Notices have been issued.
Particularly with regard to recovery of read on articles 10,000 securities. Petitioner number 1 shall meet investigation officer once.
All this.
My lord, I'm deeply obliged, my lord. I'm deeply obliged.
Next.
71.
My lord, 71, I am for the de facto complainant, my lord.
Yes, I am for the petitioner. This is the third consecutive FIR, my lord. About the self for the person, that is the petitioner is found to be land of the de facto complainant, my lord. That is the allegation. My lord, sections are under section 354B, 321, 323, 322, 325, 425, 441, 57, 503, 506, 507, and 34.
Petitioner's content, there is a civil dispute between the parties. They are the
My lord, kindly, my lord, may I submit, my lord, one thing? They are the land mafias, my lord. Several cases are pending against them.
Opposed a prayer and a lawyer for the de facto complainant submit. Petitioners are seeking to oust the de facto complainant from his land in force. We have considered the materials. Petitioner, they have criminal antecedents. We have considered the materials on record. Petitioners have criminal antecedents. It is contended they are seeking to oust the de facto complainant from his land. Keeping in mind the opposite facts, we are of the opinion the custodial interrogation is not necessary. Movement of the petitioner is required to be restricted in order to instill confidence in the mind of the de facto complainant and to prevent commission of similar incidents. Not to enter Matigora procedure.
One thing, whether the injury is simple.
Grateful.
72, I am not pressing the substantial petitioner already.
Petitioner arrested, application is dismissed as inclined. Next.
73, I am for the state.
All right, other matters too. 73. What is the nature of injury?
Serious, serious. And 164, 164 is also there.
Yes.
Green. Backside of the report.
Statement of the injured indicate the petitioner in the assault. Injury report shows grievous injury around the neck. In view of the nature of the injury and perhaps the involvement of the petitioner in the crime, we are not inclined to grant. Next.
74. Must have the include one day accommodation.
Another Vishnu Bodha has been rejected Vishnu Bodha's bail.
It's on Monday.
Monday. All right, this is that matter. That boy.
But charge pending is charge Monday.
Next.
75, no, I am for the petition for 1 day accommodation. Kindly, keep one second. Simply, I have to check the case by case.
My lord.
1 day accommodation. Kindly make it not. I cannot go through the case diary properly.
At page 16, my lord. This is of my implication is my lord is suicide note. And can we see the FIR? Another question is on bail.
Suitable application was withdrawn or
not this one. I was not there at that time.
So was the suicide.
Not actually, well, I cannot go through the case diary
All I
properly.
know.
Kindly make it.
All.
Not today, not today.
76 under the question, Lordships.
76, I am having got this.
Lordship, I have served on the defective, but the service has not been completed due to insufficient address. And the allegations are of
24. Next. 77.
My lord, I am appealing for the victim. I am appealing for the victim. My
lord, I am for the de facto complainant.
29 subsection 3, 150 subsection 2, 117 303 subsection 2, 326 G, 3 of the 5, 3.2 of the PLS. And kindly see the involvement of the report. There are 7 accused persons and civil dispute.
My lord, they have set fire to the canopies. Looted construction materials. My lord, they are the land mafias. Principal accused was granted interim bail. His bail was cancelled. My lord, he committed similar offense while on bail. Others are absconding, my lord. They are the land grabbers. Series of cases are pending against them.
Yes.
My lord, may see.
I don't have that.
My lord, the basic intention starts from the FIR 744. But the present petitioner have been named as an associate. Direct name was not given. Second FIR after 2 days, which is at page 3.
Why you are not adding organized crime here?
Yes, 111 has been already, my lord, my order sheet is with lying with me.
1 second, 3 people cannot talk at the same time. You are appearing for whom?
My lord, I am for the de facto complainant,
You are appearing for whom? Then
Why?
how can you speak when a senior is speaking? This 111 has been added.
Yes, my lord. While cancelling the 111 added, my lord, Mohammed Salman's bail has been cancelled.
Has section 111 of the BNS been added?
Yes.
Huh?
Yes, sir.
All right. Petitioner contents, there is a civil dispute. We are rejecting your prayer. Petitioner contents, there is a civil dispute between the parties. He has been falsely implicated in a series of cases. Co-accused are on bail. They pay for bail. Learning.
Is the resident of Bihar or
We have considered the material, learned lawyer for the state prayer. He contends petitioner is implicated in similar offences, full stop, and is a member of an organized crime and is involved in similar offences.
There can be a number of cases.
Offense are, we have heard your lecture, sir. Now let us give our reply. Offense under section 111 of the PNS has been added to the FIR. Learned lawyer for de facto complainant submit. Interim bail of co-accused has been cancelled due to post-bail conduct. We have considered the materials on record. Petitioner and co-accused are members constitute a gang of land grabbers. A number of criminal cases have been registered against them on similar allegations. It is contended petitioner is not a resident of the locality and has been falsely informed. Statements of witnesses speak otherwise. Interim bail granted to co-accused have been cancelled due to post-bail conduct. Custodial interrogation of the petitioner under such circumstances, post-bail conduct and organized and offense of and organized crime and offense under section 111 BNS, primarily organized crime, has been added to the FIR. In view of the gravity of the offense, we are of the opinion custodial interrogation of petitioner is necessary and this is not a fit case to grant and next.
78.
Allegation that 84, 85, 84, 50 of the PNS and with the section 3 and 4 of direct provision.
Attempt to rape against whom?
Brother-in-law, allegation brother-in-law, is attempt to rape, even allegation, I have a relation with my both. Judicial statement of the deputy. All other granted and disputable by the law. After marriage, physical and mental torture, they want to dowry.
Submits he is the husband of the victim lady and has been falsely implicated. Allegation of illicit relation with his sister-in-law is out and out false. He prays for anti-treating and lawyer for the state opposed the prayer to consider the materials on record. Allegation of torture over dowry are general and omnibus. Possibility of false implication. It is omnibus. Further allegation that petitioner had illicit relation with his sister-in-law is has to be assessed at the appropriate stage of the proceeding. Was this allegation in the FIR?
Yes,
Has to be assessed at the appropriate stage of the proceeding. However, custodial interrogation for progress of investigation is not necessary, and petitioner may be granted access to bail subject to permission. Being investigated, observe answer will come further notice. Next.
79.
Lord, I have for the petitioner this one. Yes, Lord, initially the dispute was not two ladies and some local boys, Lord, of the locality, some altercation took place. And later on, Lord, a criminal angle has been given to that Lord, dispute. Lord, I am not the FI named accused person.
Lord, I have not received the CD yet.
Not today. It's not today?
My lord, 24?
Not 24. Why 20?
Tomorrow. Tomorrow.
Or day after tomorrow?
Yeah, that is 24.
Next.
80.
490 to 307, I am the husband.
Injury and
12 years of
But
marriage.
she was admitted to the hospital, my lord. She was administered span the OPD tickets are there.
She was administered?
Administered span 5,000. Name of the benefits.
That is mainly seen.
It is in 25. So injury report, there is no injury report.
All right, we have considered the maturity from record. Incident occurred 12 years after marriage, allegation of torture are general and 12 years after marriage. Whether the alleged assault was with the intention to commit murder has to be assessed at the appropriate stage of the proceeding. In light of the aforesaid circumstances, we are inclined to grant meeting this. Next.
81.
Lord, I am appearing for the petitioner. Lord, 341, 307, and Lord 354. Lord, other accused, they have been granted bail, anticipatory bail. If you Lord, kindly turn to page 24, 24, standing on the similar footing.
Consider the materials on record. Who accused have been granted PRS bail. Petitioner stands on the same footing and may be entitled to similar relief. Hello.
82.
Your Lordship, the advocates on record, Mr. Saurabh Margul is out of station for his treatment. If your Lordship would kindly take the matter for tomorrow. Both for 82 and item number 83, your Lordship.
Not put it, why not 12?
My lord, extension was.
What?
This is for extension of my lord, interim order.
We are inclined to hear it finally. Where is the case diary?
Case diary, my lord, with me.
Tomorrow bring the case diary. Extension of it. Next. Same. 82, 83 tomorrow.
Grateful, Lordship.
Eighty-four.
Appeal connection, bail connection with appeal.
And I'm for the state.
What is the condition? Fight it out. We have considered the evidence of the minor child PW2 She identified the appellate. He was wearing a red t-shirt and disclosed his name as Dipankar Bhota. No, he identified the applicant in the past. He just child. He identified the applicant. He was wearing a red t-shirt. At the time of the red t-shirt when he kidnapped her. Thereafter, she was detained and raped. PW2 and her parents have identified the appellant in court as the miscreant. Age of the PW8, PW10, medical officer proved held radiological examination and no, it's held medical examination on the victim PW3 and found her hymen ruptured. In light of the evidence on record, victim is a minor. In light of the evidence on record,
85, my lord, I am for the appellant. My lord, paper book is already ready. My lord, sir, kindly take up the appeal for final hearing and any day, not this, but any day your lordship desires, lord. What is this condition? Lord, life. 304, lord.
Or let us keep it not to be. Fine. We'll dispose it of at this stage. Mr. Odit, you are ready. How many witnesses are there?
10 witnesses.
Paper books are ready, matter is urgent for them. So there is a dying declaration. There is a dying declaration. And Akash is as injured witness, ran away from the spot, find father killed children, daughter.
Yes.
Akash is very vital witness. Yes. But not an eyewitness, because before the incident, Akash was attacked and Akash ran away. Then when he comes back, he sees his sister dead. And local people is Lakshmi. Tomorrow we'll dispose it of. We've understood.
Tomorrow the hospital is already having a single bench one to go.
We'll do it, don't worry.
Or later tomorrow.
Small appeal, one SW4 and the medical. Next. Yes.
Lordship, pray for not good.
Why not?
Lordship, Mr. Bhumi is appointed by CMC. He will read the notice.
Next. 87, Sohan Chitri, Kego, Toro Ganguly.
Yes, sir.
All right, Wednesday. Toro is not available. Yes, Wednesday. 88. Wednesday.
89.
89.
Not one, tomorrow I will done. Tomorrow.
Mr. Mozunda, narcotic.
tomorrow.
No way. No suspension of
Tomorrow.
Bilal Shahabuddar, narcotic. How long are you in custody?
I was on bail. There is some mismatching of samples.
Mismatching of subject at the time of charge.
One day. Tomorrow.
Next.
90.
No, tomorrow. Who? So where is he?
Lordship, item number 91.
Oh, you are for 90? Not today. 91.
91, 9, Lordship. Komal Roy.
19. Komal Rai. Who is there in Komal Rai?
Yes, Lordship. I'm for the appellant, Lordship. Appellant was convicted under section 376 and 448 of the Indian Penal Code. He has been sentenced to undergo 10 years imprisonment for 376 and 6 months for 448. And there is a fine of 50,000 also, Lordship. And Lordship, during the course of trial, the appellant was on bail. And now I am in custody for about this, Lordship.
Appellant contends that the victim's version. Who is victim, PW? What
9, Lordship.
Why should we disbelieve the victim? Tell us.
PW 9 is the victim, Lordship.
Why should we disbelieve her?
Because Lordship, in her cross-examination, she has stated the accused entered into the room and touched her and thereafter fled away. That has also been taken. Lordship may kindly seize para 71 of the judgment.
Version of forcible rape is improbable. She does not explain how the appellant gained access to the room, inside the room. Full stop. The sentence is one of term imprisonment. He prays for suspension of sentence. Not a lawyer for the state opposes the prayer. We have considered the evidence on record. Victim deposed. She had gone out to answer nature's call when the appellant had entered the room. He raped her against her will. Stop.
Page number 7 is the internal page 7 of the judgment, Lordship. That is on page 22.
Children have been examined?
No, Lordship. Children has not been made a witness and not they have been examined.
Husband examined. Husband is in Gujarat, husband examined. What about the two children? She has two children.
Not examined.
Then they were in the house. The victim is a married lady and had two children. They were, her husband was working in Gujarat. On the fateful night, the children were in the room. These two vital witnesses have not been examined. In light of the aforesaid lacuna, we are of the opinion appellant has made out an arguable case in appeal. Sentence is one of term imprisonment. Appellant was on bail during trial and did not misuse liberty in any manner whatsoever. In light of, accordingly, under such circumstances and in view of law declared in Bhagwan Shinde Gosai, we are inclined to suspend the case. Next.
Grateful, Lordship. Grateful.
92.
92. Dismiss the result as what is the use of victim means.
Only one day.
No. See, section 6, we are not going to allow.
The mother of the principal.
Huh?
Mother of the principal.
What about the principal?
He is also.
He has
not filed the suspension of the.
He has appealed.
Yes.
You were on bail during trial. Huh? You don't have the bill. No, give notice. Officer in charge, so-and-so police station shall notify the victim with regard to pendency of the application for suspension of sentence and a right to participate, matter will appear on Monday. Monday. 92 by 93.
93 for the state. Should I think for 1 day? Sir, 9 years old girl, POCSO, 15 years sentence.
No accommodation. If necessary, or opportune, that 2 PM matter, if necessary, will sit on 3 PM, right? Not 3, have more matters, because we'll dispose of your appeal first. Hope we won't take that. Yes. That you say that you will find sense in it. The sense should come to sense. Yes, next. 94. Appealing. Single appellant?
Yes.
Huh?
Three of them were convicted under section 376D.
So, what about the others? Have they filed appeal?
No.
AJ, department shall submit report whether appeal has been preferred by other convicts. In the event appeals are preferred by co-convicts, all appeals shall be listed together. Full stop. Matter will appear day after tomorrow.
Ninety-five.
95. Same orders. Whether co-convict. I think is correct. State, who is appealing for state, anyone appealing for state? There is a delay of 351 days. There is a delay of 351 days. You take a copy of the application. If a public prosecutor is directed to department shall serve a copy of the application on the public prosecutor. Application for condonation of delay on the public prosecutor. Officer in charge, Chitai Police Station, shall serve copy of the application for condonation of delay on the victim and submit report on the adjourned date, Monday. Next.
96.
96. Jail appeal.
Mr. Bhomik has been appointed in this matter, but Mr. Bhomik has been appointed in this matter, but we haven't received the copy yet.
So when will you file the appeal? Mr. Bhumi, when will you file the appeal?
Not section 3 appeal.
Ah,
We did not get the copy.
getting a why?
We have applied for.
What happened?
For the copy of the memorandum of appeal.
Memorandum of appeal is not there, sir. You have to prepare the memorandum.
We have applied for memorandum of appeal or inspection.
This is the inspection. See the inspection. What do you have applied for inspection? Have you got a copy of the judgment? Anything?
No one.
So ask your DLA, SLS, who is the secretary here?
The under register.
Please request the register to provide the.
Actually, we have requested.
All right, Mr. Bhomik, it's time to take steps in the matter. When will you be able to?
Next week, no?
Adjourn 1 week. Next.
My lord, as per the petitioner, this is my prayer. This is my prayer for renewal of bail. My lord said lastly rejected my bail on 16/5/2024. It's at page number 2 of my plan application number 2. Page 10 of plan. There's a limitation of vulneration of delay as well, that's plan 1.
How long is the delay?
Well, it's 4 years, 6 months. 4 years, 6 months, statement.
4 years?
Condition. My lord's apology, 371 days.
371 days, madam, as per law, beyond 90 days, you cannot follow.
My lord has the discretion to.
Do we? We have the discretion.
It's my lord's.
Yes.
I'm not.
Huh?
My lord, subject to correction, my lords of the discretion.
We do have the discretion, Mr.
I'm representing respondent National Investigation Agency.
Correct. On behalf of National Investigation Agency, we were asked you, do we have the discretion to condone a delay of 371 days?
So at the outset, I would like to submit that the instant application is not maintainable. The order against which they have filed this appeal against the same order, they had previously filed an appeal which was registered and numbered as CRA 73 of 2024. 23, I'm sorry, and that was filed on 7th of December, and on 11th of December, the same was admitted by the division bench headed by your lordship. Ultimately, that application came up for hearing on 16th of May. Again, your lordship, the division bench headed by your lordship was pleased to reject the said application. And with direction upon the prosecution to conclude the
trial. Whatever, give us the number of that appeal.
CRA 73 of 2023.
CRA 73 of 2023. Appellate had assailed order rejecting bail dated 28/11/2023 in CRA 70 of 2023. The order, the appeal was disposed of by a coordinate bench presided by one of us, Amarnath. Video order dated
16th May.
16/5/2024. The said order had not been assailed before the Honorable Supreme Court and has become final. Again, the appellant has assailed the self-same order rejecting bail in the present appeal, which not only is barred by limitation, present appeal. In light of the aforesaid facts, we are of the opinion the present appeal is not maintainable. That apart, the appeal is also barred by limitation. Accordingly, the appeal is dismissed as barred by limitation. We find no reason to condone the delay. Limitation, appeal is barred by limitation. Accordingly, the appeal is dismissed. Yes, next matter. Defective section 5. All right, you take steps, adjourn one week. Fine. Okay, list along with cran so and so. Cran is there. As a cran is treated on days list. Copy of the cran is served upon Mr. Aditi Shankar. Well, having considered the averments in the application for condonation of delay in referring the appeal is condoned. Appeal is admitted, issue usual notices, call for records, liberty to pray for suspension of sentence upon notice. Next. Sudhir Tamam.
On the appellate, there is a delay of 10 days.
Yes, we have filed as a
99, I have filed the CRAN.
Have you filed?
CRAN, yes, my one.
With the number.
CRAN 1.
Huh?
Limitation CRAN 1.
List along with CRAN 1. Then Laksham appear. Copy of the application is served upon Laksham. Stuff. After the learned lawyer empaneled with the state of West Bengal, when the awareness delay is condoned, stuff. Appeal admitted, issue usual notices. Oh, child is there, huh? Child.
Victim is being
Laksham is survey popular on the victim. Monday. A copy of the application of this state shall serve a copy of the application upon the victim and intimate her of a right to participate in the matter through legal assistance, and her right to legal assistance through Monday. Yes, next matter. No. Next. 100.
100. This is a appeal on a conviction in a NDPS case. There is a defect, my lord. There is a delay in filing the appeal, my lord. We have filed an application for confirmation of delay. I think it will be either on the record or it will come with the record.
Hey, can I run outside? Confirmation? List for day after tomorrow.
As you watch.
Next.
101.
101. Department shall submit report whether co-convicts have preferred appeal. We'll do 1 week, next Monday. Next.
We only long today and the current record of submission and he said the file. Great.
103.
Lordship, I am for the petition, this an application for relaxation of bail condition, there was a condition by grant what to appear once in every.
Yes, my lord,
Report is compliant, report is filed. Petitioner has complied with the condition of bail.
Let's pass more one year, yes, complying with the condition.
Complied with the condition of bail for 1 year. Further attendance or progress of investigation is not necessary. Accordingly, condition of bail That is, you need investigating officer once in a week, is with, he shall meet the investigating officer as and when necessary. Next.
আরে কথা বলবেন 104
104. Who is there? Nobody, not today. 105.
105 I'm for the petitioner in 104.
No, you're sleeping. Aditi? Complied with condition? 104.
I have applied for your lordship for the time of, for the extension of time. 430 was allowed.
Okay.
13 December 2023.
Actually, my lord, due to financial poverty,
What financial?
they are garden level. My lord. They are garden level.
All right. Petitioner was unable to appear before the jurisdictional magistrate and submit bond due to financial stringency. Under such circumstances, and as a last opportunity, petitioner is directed to appear before the jurisdictional court and pay for regular bail within 4 weeks from date. No further extension shall be granted. Dismiss, dismiss. Instruction dismiss. Next.
106.
106. Same, restoration dismissed. Nobody appears, dismissed. 107.
107. Within the condition of the meet the IO, I already have complied all the.
How long you have complied?
That is comments on 18th July 2024 and lastly
7 months.
7 months.
Get us. Report is there.
Yes.
Yeah, yes, complied.
Yes.
All right. Appellant petitioner has complied with the condition of bail for last 6 months. Yeah. Further attendance for to investigating officer. Further attendance to the investigating agency for progress of investigation is not necessary. Accordingly, we waive the condition imposed on the petitioner that the investigating officer once in a while. He shall meet the officer as and when necessary. Next.
108.
First time for the petitioner. Petitioner have filed this petition for modification of condition. First, anticipatory bail was granted to the petitioner and order in at page 9 on 12th of August. And condition was imposed on him that the petitioner shall appear before the court below and pay for regular bail.
Petitioner was unable to appear before the jurisdictional court and pay for regular bail within the stipulated time. Under such circumstances, as a last opportunity, petitioner is directed to appear before the jurisdictional court within 4 weeks and pay for regular bail. No further extension shall be granted. Next.
105.
Yes.
Paying for modifications, yes, actually we order money. If there was a condition, for example, in our requirement bench was pleased to impose a condition that he shall not enter into the jurisdiction of Darjeeling district. Lordship. And we have complained.
Not now.
But co-accused has been, investigation completed, co-accused has been modified up to that extent.
Investigation has got nothing to do with your entering. Restraint on your entering is to protect the witnesses.
No,
It's got nothing to do
But
with
but the co-accused, my lord, in this case, the co-accused has been, his bail order has been modified to that extent. Here.
Page.
Here. I might.
Same order. Condition of being imposed on co-accused has been modified, dated, order dated 26/11/2022. No adverse report is placed against the petitioner. Under such circumstances, we are inclined to modify the condition of guilt of the petitioner on similar lines. Petitioner may enter jurisdiction of Calcutta Forum. Next.
110. I'm asking for petition. Learned, honorable coordinate bench granted the petitioner anticipatory bail, but in the FIR, her name has been mentioned as Josnara Khatu, but in the other card, it is mentioned as Joshan Ara. Due to that reason, she could not surrender before the learned.
What can we do?
I'm paying for necessary orders for.
Huh?
Both the person will be kindly be ordered to say.
So why should we? Your Vakaratama says you are Joshanara. This is your Vakala. Joshanara. Then why should we allow you to change your name?
In the other card, his her name is mentioned as Joshan Ara. But in the FIR, it is mentioned as Joshara Khan.
Whatever, the other card.
She's the family member of the.
So you surrendered as Joshana.
She tried to appear surrender, but due to that reason, the court
is working
This is the ground in Aadhaar card, Josnara.
You say whether Joshanara and Josnara are the same person or not.
That I have to.
Yes, get the report. Report we file.
Tomorrow.
You can file report, no difficulty, day after day.
Day after. Wait.
Yes.
111.
This matter, the petitioner filed an RSG petition because this is the case of incident for the investigating agency filed the report under 304B, your lordship. So the application filed for the court below your lordship, before the learned court, your lordship. But that is pending, and the estate of your lordship, I would like your lordship to take place. There is
But for that, why should bill be cancelled?
Your lordship, in this matter, I would like your lordships to peruse annexure B, that is page 17 of my petition, your lordship. He is the landlord where the petitioner's sister and her husband used to reside, your lordship. That is the 164 statement.
Where is the accused?
After several.
Where is the accused? Has the accused been served?
Yes, your lordship, on several occasions, even once to the police, your lordship, they appeared once on 11th July 2024. There was a direction to file opposition by Justice Bharadwaj and
who is he? Krishna Rai.
Yes, your lordship, they appeared and on 11th Justice Bharadwaj and.
Who is Krishna Rai? You don't know. A Sharkar, Supratim Nath.
Yes, maybe they are.
He is practicing man of district court. I think. District court.
Oh. All right, you give a notice for the opposite party number 2 accused are not specified. Officer in charge so police station shall direct opposite party number 2 accused to appear in person or through their learned lawyer positively on the adjourned date, failing which appropriate orders shall be passed. Tuesday week. That is 20. Right. Next, same order.
112. Who's person, your lordship, same.
Same order. Oh, 11, 12. 113.
This matter, lordship, the opposite parties, I will not for to validate your lordship's condition.
Yes, give a report with regard to.
Especially at least once, the locality to provide the medicine and the food.
All right, report is placed on record. Report shows petitioner had entered the locality once, but for but to provide medicine and food, that is humanitarian research. In light of the aforesaid fact, we are of the opinion the violation of condition is,
So many cases
is technical and not is a technical one. Under such circumstances, we are not inclined to cancel the bail. However, we direct opposite party number 2 shall scrupulously comply with the conditions of bail.
Lordship, so many cases have been raised.
Next. 114
For the state.
Accused.
I have tried to solve
Service not complete. Afresh, start afresh. Opposite party number 2, petitioners shall serve notice upon opposite party number 2 through registered speed post with acknowledgement due. Matter will appear 4 weeks since. Next. 115.
115.
Lordship, I'm praying for one day accommodation lease.
Why? You're for whom?
I'm for the petitioner, Lordship.
You have served them. Then let service be done. Opposite copy of the application be served upon opposite party on one state to public prosecutor at will. Matter will appear 8 weeks since. Next.
That's all right.
115.
Because after the petitioner, I served to the state, but the opposite party are not some lordship.
Petitioner shall serve opposite party. How many opposite parties? Through opposite party number 2 through registered people acknowledgement due. File affidavit service matter will appear 8 weeks since. State के सर्व करा होगा मिस्टर ओपन चौधरी फर्स्ट ईयर. Next.
117.
117.
Lordship, Lordship, during the time of filing, I made delivered to file without certified for Lordship. Lordship, kindly taken up the matter on 24th. Lordship, I'm on the state. In the meantime, I'll
Adjourn for a week. Next.
118.
Yes, Mr. Mojumdar, have you served?
Lordship, the problem in the service by which address that was provided by the accused in his bail petition. We are not able to serve on that address. It has been retried by.
Personally, sir.
So it might have been kind of direct us to service the advocate on record.
No. Why should advocate on record? There is a bond, surety, through the surety.
The surety.
Yes, service of the copy of the petition be served personally upon the opposite party, directly as well as through his sureties. After the service be filed, adjourned 1 week. No, you have got your surety physically go and serve. You don't know where he is. Next.
119.
119. Nobody appears. Dismiss proceedings. All right, serve. Copy of the petition be served upon opposite party number 1 through public prosecutor, 2 through register speed post. Matter will appear.
Copy has been served.
To opposite party number 2 through register speed post with acknowledgement due. After service filed on adjourned date, matter will appear 8 weeks hence.
It is, yes, number.
Same order in the next
120, yes.
You are active, right? Yes, now 121.
But I am for the appellate not it is the appellate judge. The special invitation will not challenge the order of the
Will time informed?
Yes, they have already appeared, not there was a. It is one of them.
Only one of them.
All right, leave is granted. Leave is granted to prefer appeal. Now you file the memo of appeal, we'll hear out here.
I'm grateful. I'm grateful.
So that's about this one. Having produced the grounds in the leave to appeal, leave is granted to prefer appeal. So I'm so. Disposed of, next, Union of India.
122.
This is an appealing as acquittal, especially.
So leave is granted. Leave is granted. Having considered the averments, your time in time and forth. Within 30 days, please file the petition memo. Under the law, you have to file the memo. Other matters tomorrow. Today's bench will not sit.